Welcome to NeLI Pod, the official podcast of the National eDiscovery Leadership Institute. Hi, I'm Daniel Gold, your co-host and navigator through the evolving landscape of eDiscovery.
And my name is Brandon Mack. I'm the co-host of our podcast. Our guests, from judges to eDiscovery professionals, share insights that cater to all experience levels.
Whether you're looking for a broad overview or in-depth technical analysis, this podcast is your gateway to understanding and implementing effective eDiscovery practices.
It's important to note the opinions expressed on this podcast are those of the individual guests and the host, and do not necessarily represent the views of their respective employers.
We're here because of our passion for eDiscovery and our commitment to providing free, accessible educational content to legal professionals everywhere. And welcome back to another NeLI Pod. Today, we have the privilege of speaking with a highly respected, accomplished, and prolific voice in the eDiscovery space, Kelly Twigger. Kelly is the CEO of Minerva 26, formerly known as eDiscovery Assistant. She's also the mastermind behind a very innovative online legal database focused on eDiscovery. She's also a practicing attorney, created the highly regarded ESI Practical Guides, hosts the Case of the Week series, and regularly contributes to panels and webinars on cutting-edge eDiscovery topics. In short, if there's a discussion happening in the world of eDiscovery, well, it's fair to say Kelly's voice is a part of it. Beyond her impressive credentials, Kelly is known for her dedication to advancing eDiscovery education and awareness. And today, we're going to be diving into some of the most pressing, technical, and forward-looking topics shaping the eDiscovery landscape. From hyperlinked documents to GenAI hallucinations, from ephemeral data to the trends shaping this year and next, Kelly has insights that can help us better understand and navigate what's ahead. Kelly, welcome to the NeLI Pod. We are thrilled to have you here.
Thanks, Daniel. Thanks, Brandon. Thanks for having me. I really appreciate being here.
Hopefully we didn't miss anything at all in that introduction about who you are and what you've been doing for the eDiscovery community.
You know, Daniel, sometimes there's too many things. And when you've been doing it as long as I have, you just stop counting. It's like birthdays, right? You just stop adding to the list. Oh, one thing I will add, and that is that I'm teaching at the University of Colorado at Boulder at the law school. So I'm teaching their eDiscovery section there. And that has been very illuminating in terms of bringing the conversation down to a level that everyone can relate to. So it's been a good experience for me, and I love teaching.
Love that.
Well, Kelly, I hate to dive right into the deep, ugly end right away.
Let's do it.
That's what we're here for today. We're starting to talk with the really technical stuff. So let's start with modern attachments. Hyperlinked documents, modern attachments, they've become really ubiquitous in the business landscape today. And obviously, those of us who are in eDiscovery understand some of the problems that they create, the challenges they create in being able to really collect the right versions, being able to collect them and process them and so forth. From your perspective, and as you've seen this problem sort of morph and mature over the last few years, what do you think remain to be the biggest technical challenges that we have to being able to properly identify, collect, and ultimately review these documents in these formats?
Well, there are two challenges. One of them is technical and one of them is legal. The legal challenge is that the courts are kind of all over the map as to whether or not hyperlinked files, which is what I call them, and what we call them in Minerva 26 is our issue tag, whether or not hyperlinked files are in fact discoverable. And I think that's a really interesting legal analysis. Judge Cisneros, who is one of the judges in the Northern District of California on the In Re Uber Tex class action, has issued a number of decisions on hyperlinked files. And personally, I find her analysis to be the most thoughtful. I don't understand why information that was physically attached to an email is now different than information that's physically attached via a link, why that should be considered separately from a legal perspective. That's the position that Judge Cisneros takes. So there's a legal issue. Are hyperlinked files considered attachments for purposes of discovery, meaning that they are discoverable, right? Then there are the technical issues. So we don't have an answer to the legal question. As in all eDiscovery case law, the judges are all over the map. And quite frankly, a lot of the times, if the judge is not doing as the job that Judge Cisneros is doing, then it depends on the parties bringing experts to the table who can adequately explain what the technological capabilities are of the entities that are having to produce documents from hyperlinked files. Sometimes the legal question of are hyperlinked files attachments gets modeled up with that question of the technical, and I think they are two separate issues. So I would like for them to be two separate issues. On the technical side, there are a number of issues with hyperlinked files. One is who shared the hyperlink and is that person still at the organization? Two, does the person who you're collecting data from have access to the linked file? Three, what's the version of the hyperlinked file that you're trying to collect? Do you want to collect the contemporaneous version, meaning the version that was sent at that link at the time the email was sent or the message was sent? And how do you do that? And all of those things are technical problems. So the case law sorts out. There are some tools out there that have worked to solve this hyperlink problem. Some of them are specific to service providers. Some of them, like the FEC tool, forensic examiner collection. I'm getting the name wrong. Apologize.
And the software is made by a company called Metaspike. Yes, correct. Go ahead.
And that's the tool that's mentioned in the Nichols v. Noom case, which really kicked off our hyperlinked files discussion from Judge Catherine Parker back in March of 2021. And so the question is, what can the tool do with the software that you have? Now, we're wading into some weird territory in this area because in the Uber case, Judge Cisneros said to Uber, hey, you guys knew about this hyperlink issue. You're in litigation all the time. And you chose to use Google Vault, and you knew, or you should have known, that Google Vault doesn't allow for you to collect contemporaneous versions of hyperlink files out of it. Google Drive, the active version of the Google box, does. So by virtue of you choosing that technology, you made a choice, and now you have to expend the effort that's required to provide that information. So it's kind of a really weird place we're finding ourselves in, where we haven't had a situation that courts have started to say the choices that you're making as an organization about the technology that you choose impose these additional obligations on you, and you therefore still have to meet those obligations. A lot of the pushback from corporations, defendants, and rightly so, has been, wait a minute, we have proportionality here, and the costs of us going and manually finding these hyperlinks is too much. So there has to be a balance. The courts are trying to find it. It's a difficult one, and not every judge is as educated on the issues as they need to be when they're making decisions. So there are a lot of technical challenges. My view is that we're going to continue to see this issue be a problem until the services that we use to create, store, send, and receive information provide the ability for us to collect contemporaneous hyperlinked documents with the documents as attachments. My understanding from Microsoft Teams or from Microsoft is that, and this was back from, I think, December or January, when Stephanie, whose last name I've suddenly forgotten, and Rocky Messing did a talk with Tom O'Connor on his channel, and they specifically discussed how if a company sets a retention policy in Microsoft, that from that moment that retention policy set, those contemporaneous versions will be stored with or can be captured from the message that's sent. But when that retention policy is set is when that comes into play. So if you have a duty to preserve today, and the email is from the last 2 years, and you set the retention policy today for preservation, it will not preserve those hyperlinks retroactively. So it's very much a technology issue of how does your technology work? What are the capabilities that you have in-house to deal with that? And what are your legal obligations to spend money to make that happen? And I think the other really crucial point out of all of this is that counsel have to be very aware of the hyperlink issue, and they have to understand at the outset what the technologies are that their client has and how they're going to be able to deal with the issue, what the technologies are that the other side has and how they're going to be able to deal with the issue, and how much it's going to cost, how many documents you're talking about. And then you have to come up with a plan for the court. And that's something that I thought the lawyers in the In re Uber text decision did very well. And I did talk about that on our Case of the Week episodes that deal with those cases. But what just came up in that case recently is another issue, and that is that in their ESI protocol, they wrote about hyperlink files. They didn't call them hyperlink files, but that's what they wrote about. They wrote a section on it. It was very well worded, and I had put it out to people like, hey, this is a great way to handle this. It has to be with your case. But um, what they did is they specifically limited hyperlinks to Google Drive. And now the plaintiffs have discovered that there are hyperlink files in other sources of ESI that weren't provided for in the ESI protocol. And so then the defense tried to say, hey, no, we limited this to Google Drive. And the court said, you can't do that.
Kelly,
So
you
sorry for
provided.
all of that, but it's just a huge,
Yeah.
it's a really big issue.
It is a really big issue. And so I want to take a moment to step back from everything you said. I want to unpack some of it that I think will be really important for all the listeners. So the first one is for those that aren't aware of what we're calling hyperlink files, right? Hyperlink documents, minor attachments, etc. It's basically works like this. And Kelly, you tell me where I'm incorrect about how I'm laying this out here. If I'm sending over to you, Kelly, an email that's dated Thursday, April 17th at 12:18 Central Time and has a copy of a contract that you and I are redlining together, right? And I've redlined this contract, you've provided comments, and then we're in litigation about this contract a year later. And then we go ahead and we grab all of my emails, grab all of your emails, and we've got not an attached document, a physical document, right? But now we've got just a hyperlink. And if we pull the hyperlink, there is a hazard that we will end up pulling the document as it exists 1 year from now, as opposed to April 17th at 12:18 Central, correct?
That's exactly right. And the other
Okay.
issue is if the litigation is about the scope of the document that we signed and who intended what in the language of that document, all of those comments and the red line changes on each of the versions that we exchanged via email or via link are relevant. And so then the question becomes, instead of getting every version of the document, can I get a log from the software that shows who made what changes to what paragraph on what date and who made what comments and how the comments were resolved? What does that log look like? So yes, you're articulating it spot on.
So it almost seems like that there's a lot of various different things that need to go right from what you just explained to all of our listeners. And one of the things that needs to go right is all companies, and whether it's general counsel or CLO or it's legal operations professionals within an organization, or maybe it's a legal services provider, whomever it is, they need to be able to talk with the IT team and they need to talk with the legal department to find out how they're currently doing things and then probably create policies around the retention system and also in relation to and make sure there is alignment around those hyperlinked files, because the more that they know internally, by the time they bring in outside counsel, then outside counsel should then be, there's another thing, outside counsel needs to be educated and make sure that in all the ESI protocols, ESI agreements, and in all conversations with their clients, that they understand everything about that data retention schedule, about how they are sharing files, whether that be in Google Drive, whether it be in Teams, whether it be in Slack, or maybe it's even in Zoom. Does that sound about right as well, Kelly?
Yes, I would take it one step further, and that
Please.
is we talk a lot about what we call information governance consulting, where we're talking about really planning for mitigating the risk of costs of ESI in litigation. And um, look, the hyperlinks thing it's a bear. There's no question about it. But there's a big, like you said, talk to IT. And the reason that my sort of, I don't know, red flags or whatever went up is because IT in an organization builds the bookshelves of your IT infrastructure, and they allow all of the different pieces of software and all your virtual machines and all your databases and everything to integrate together and to work so that as a user, you just sit at your desktop and you access whatever information you need to do your job, right? There's a million things behind the scene, much like maybe the listeners can relate to setting up an eDiscovery database, right? When you're setting up a review database, there's so many details that you have to pay attention to that the lawyers never even think about, right? But IT is meant to build those bookshelves. Now, When you want IT to go and get the red book on the fourth shelf on page 41, because that's the one document that you need for litigation, that's not IT's job. And so when you say go talk to IT, as long as the conversation is this, Daniel, thanks so much for your time today. I really appreciate it. I need to talk to you because in legal, we have this issue now of our employees transmitting documents via hyperlinks. And we need to understand what is currently being maintained, what our options are to change those settings, what the ramifications are for the business if we change those settings, whether we can change those settings at a time and place today and have them apply retroactively. You need to have that conversation so that you really understand how the tools that are being used by your client work. And then you have to have an additional understanding as counsel as to what the capabilities are to use additional outside tools to come into the company's systems and find what you need if the company's systems can't provide it. So it's not that different to what we did before we had all these things from Microsoft and Purview that folks use now, right? You have to bring external tools in. So there's a balance of one, understanding IT, two, understanding what else exists in the marketplace to go and get what you need.
So can we talk about that a little bit? When we think about best practices, then what I think I heard you just describing was IT is building this bookshelf, and legal needs to get involved in the build of the bookshelf, at least to understand how it's being built, and maybe to some extent give some guidance on what's really needed out of this bookshelf. In your experience and in talking to other practitioners, how often is legal aware enough or at the table when these decisions are made to be able to have those discussions? Because when you're talking about implementing, whether it's Microsoft or Google or whatever it might be, IT looks at this as collaboration software built to make the business more efficient in how we
Yep.
do our day-to-day work. Is there someone at the table who's talking about the other implications of the choices that are being made so that you're not 2 years down the road having the Uber conversation of, oh, well, you decided to use this storage system, therefore you now have to carry the burden of it? I mean, who's having that conversation early in time?
Well, Brandon, I will say this, and that may be a question more for a lot of legal ops people. So our job at ESI attorneys is to act as that liaison between the business and legal and IT. So we have kind of in our little logo, we have four arrows, right? Legal, business, IT, and that's the goal is that we're at the table. So oftentimes my job is to act as that liaison to understand these risks of when you're implementing things. And for our clients, what I do is attend whatever the quarterly meeting is where IT's having, where they're talking about here's what our plan is for 2025, for 2026. Here's what we're going to be looking at rolling out, or here's what the things are on the table in order to identify areas of risk and understand where we need to consider policy implementation. I'm never going to say put a policy in place because there are pros and cons to having policies in place. And so the question is strategically identifying those risks, understanding where they are, and how you want to plan for them going forward. Most of the time, for most clients, right? Not the super litigious, the Meta, the Uber, those folks, but for most clients, a proactive thought process is really important to save money down the road because they don't have such tremendous litigation burdens that they have a lot of systems in place specifically to address those. A lot of clients have an average number of litigations, or they have, maybe three or four a year or one a year, right? And so what are you going to tell them? You want them to spend that much money? No. You want to be able to come in and have, like I said, know what the tools are, know what externally you need to be able to meet your obligations under the rules. So there is a lot of planning. To answer your question more directly, I don't know of a lot of folks that have that in place. My hope is that legal operations is starting to fill that role, and the growth of legal operations over the last 5, 6 years has been tremendous. For our clients, we fill that role.
Well, I think that's right on it, and I think that the all the data shows that you're right, Kelly, that legal operations has increased over the last 5 to 6 years. I think the pendulum is swinging back in the direction of legal operations professionals being more consultative and being more specialists as opposed to what they had become in the last few years, which is more project management focused. And we're seeing again more of a higher level learning. NeLI has been a cornerstone of eDiscovery education for over a decade. Our ability to deliver world-class programming and keep it accessible depends on the support of sponsors who believe in raising the standard of our profession. If your organization shares that commitment, I invite you to sponsor the National eDiscovery Leadership Institute. And if you're ready to lead from the front, mark your calendars. This year's conference will be held September 11th and 12th at UMKC in Kansas City. NeLI is free to attend, offers CLE credit, and brings together outstanding networking opportunities with professionals across the legal and technology communities. You can even review our decade-long history of past speakers and agendas, all available online, to see the depth and quality of the conversations we foster. Learn more about sponsoring and register to attend at ediscoveryleadership.org. I want to switch topics. We're at risk of maybe having an entire podcast just focused in on the hyperlinked documents. I want to talk about, which we could, by the way, and which there are many that are out there. I want to talk about something else that's really, very, very prevalent, and that's Gen AI. I think that what is happening right now is that we are seeing an inflection point in the legal industry and in other industries as well. But Gen AI has attached itself to every aspect of a legal professional's life. So whether it's researching, whether it's drafting, et cetera. And what I continue to see, much to my dismay, is that a lot of lawyers are not only, which I think is great, adopting this, but a lot of lawyers are just copying and pasting case law into motions. And when they copy and paste those into motions, they're not checking the citations. And when they don't check the citations, that could be a problem. And the reason why, for those that don't know, is that when you don't check the citations properly, the Gen AI tool could potentially do something called hallucinate. Now, in the 60s, hallucinating was something much different. But now what happens is that Gen AI tools are actually creating fake case law, and that is leading to a lot of ethical issues. Kelly, why do you think that this is such a prevalent issue right now with attorneys not checking the Gen AI? They're just taking it at its word, so to speak, and just copying and pasting it and not looking. Aren't there ethical principles all over the place at play here?
Well, there absolutely are. I mean, that's really kind of a no-brainer. In terms of are you breaching your legal ethics if you present citations to a court that don't exist? Of course you are. I mean, that's kind of a no-brainer.
Can you talk to us about what some of those are?
Sure. Yeah. So there have been several cases. The Mata case from a couple of years ago was probably the most widely cited one, but there's a new one every week, it seems like, where lawyers are using some Gen AI tool, whether it's a chat GPT or something else, to create arguments and identify legal precedent. So, I could go into chat GPT right now and write a prompt that says, I'm going to make up something. I have an employment discrimination case, and I need to write an argument about age discrimination with this set of facts. Write me an argument and make that we've met the standard here, and include all the legal citations that are relevant for us to draw analogous case arguments. And it will draft for you an entire argument. And a lot of folks are, as you mentioned, cutting and pasting it and putting that into a brief. And the problem is that ChatGPT is not a legal research tool. It's not a tool that has access to all of the case law from all over the country, from all over the courts. There are specific tools that do. Our Minerva 26 only has access to eDiscovery related decisions, so it's a very niche tool. But you've got to find an actual dedicated legal research tool in order to be able to rely on those. If you're going to use the AI to make that argument for you, just check the sites against a legitimate research tool. Now, why are lawyers doing that? One, time. Two, money, because a lot of clients don't have money. And we talked last week at the Masters Conference about the access to justice, and about how everything has gotten so expensive, and ESI has only made it more expensive that it prevents a lot of people from going to the courthouse. So time and money, I think, are two reasons. The third reason is the cost of legal research tools. I mean, legal research tools are incredibly expensive, and some law firms just don't use them often enough to be able to justify the cost. And then you got to remember that law firms are usually partner-driven corporate structures. So the more money they spend in expenses, the less money goes into the partners' pockets, and that's always an issue.
One of the things you mentioned there, we're talking about legal research, and one of the other places where legal research really comes to bear is in education. Legal education as young budding lawyers are learning how to do legal research. Do
Mhm.
you think that these tools, the availability of tools that do AI-driven legal research, is kind of stunting that learning process? Is it helping the learning process? How do you think that's interacting with law school students and fresh lawyers?
Brandon, that's a great question. One, I think they have to learn it, right? I mean, that's where we are, and it's changing every day and it's adapting every day. I just got the latest from OpenAI talking about how much more exponentially great their latest reasoning model is, right? And I mean, the changes just in a year are insane. I mean, insanely amazing what these tools can do. And this is the future of where lawyers are going to be. So I think they need to use the tools. Do they need to learn the old school way of doing it? Well, I guess I would answer that this way. When I was in law school, we learned how to do research in books, and books don't exist anymore. So do they need to learn how to use books? No, because they don't exist. Do they need to learn how to use and do research before that? I don't know the answer because I'll tell you the most effective researcher is the one who knows the issues and what they're looking for and understands the language of the case law. And so I think that AI can actually help with that because if I'm a young lawyer and I put in a terminology like, let me think, something that would easily be confused with another term, right? So let's say I put in undue burden, but really what I'm talking about is proportionality. In now, the AI tool may suggest proportionality. I mean, that's part of what our Minerva platform does, is if you try to argue, if you try to look for one thing, we're going to tell you that's proportionality. And we use AI to do that. So I think the students have to learn the AI, but I think they've got to learn how to use it the right way. I will tell you that I had one student in my class ask, why can't I use ChatGPT for legal research? To which my response was, don't you have Westlaw and Lexis for free in law school? But, um, I had to explain to these 20-something-year-olds that you can't use it. And here's why. Because I think there's not enough education out there on what ChatGPT really is, on what Claude is, on what Gemini is, whatever all these tools, Grok,
Yeah.
etc.
I want to dig in a little bit on this because the gray in my beard suggests that I went to law school at a time also where I learned how to do everything on the books. And you go to the back of the book and there'd be slip sheets, and I know some people listening to this have no idea even what I just said. But and I've told this story
I'm with you,
before.
Daniel.
Thank you very much, Kelly. I know Brandon is as well. And when I look back at things where there's a cognitive skill involved, very much like in utilizing the old school AAA, maps that they would give you before you go out on a trip. This is way before GPS for those that are listening, and wondering what AAA was or what a map is. And so there is a cognitive skill there that we learn that we embrace to understand how to get from point A to point B. And very much the same thing went for case law books and the codes and the statutes, because you would start connecting, you look into all of the comments and all the footnotes, and you start, oh, now I have to go grab this book. And now I just saw something and I have to grab this book. And one can easily argue that why would you do any of that? Why spend any time doing that at all when you can just type in something and you can immediately get it? But to Brandon's question, just to drill in a little bit further on this, do you think that the reliance on Gen AI, and it's only going to get better. I've seen the models, especially with Claude and its reasoning capabilities, get even better, that we are going to have a generation of law students that have lost this cognitive skill, or in the alternative, it saves more cognitive room to be able to focus in on more higher level things. I don't know. What's your take on
I
that,
think
Kelly?
I think two things. I think one thing, the first thing is to recognize that lawyers never don't have too much to do, ever, right? I mean, we always have way more to do than we have hours in the day. And more to your question of are there skills that they should be learning? I do worry about even using just online, let's just say old skill legal research online, right? Old school, not old skill, sorry. Um, I can Google, I can search, do whatever search I'm going to look for and find the cases that I want to use, right? But I also need to find the cases that are going to be bad for me. And I need to know how to distinguish them. And I will say that most of the briefs that I read today, both in my capacity as counsel, as an expert, doing some special master work, they're all advocating for their position, but there's no distinguishing existing case law that's out there. And though that's a huge piece of lawyering, is to say, well, judge, yes, the judge from you down the hall found this, but there are three key facts that weren't present in that case that are present in our case. And therefore, I need you to look at this decision from this judge in California. And I'm saying that because eDiscovery spans the whole country. And this decision from this judge in California is much more in line with our case factually. And so this is the one you should follow. And here's what we're going to ask you to do as a result of that. I'm not seeing that initial part where they're distinguishing the other cases. I'm just seeing we cite to what we think it supports our case. And I think in part that's because we find what we want to on an online platform and we use that, right? I don't know that there's a conscious decision not to address the other cases, but and then how much looking do you do, right? How much digging do you do? So I think AI is going to help you get to that. But I think one of the bigger problems we have in the law is lawyers generally learn trial by fire. They don't generally get taught how to do things, right? I mean, they get access to legal research tools, but does anyone really teach them how to learn how to do legal research? I mean, in my legal research and writing class, we had to do legal research and write a paper, and we were graded on those papers, but nobody ever came and sat with you and said, here's how you use this platform most effectively. We had free trainers at the law firm to teach us, and every once in a while at the law school. But are they really learning how to do that such that they can adapt to the Gen AI world? That's more my concern than the Gen AI alone piece of it.
Good point. Yeah, I think like our discussion about hyperlinked documents, we could talk all day about this, about Gen AI and some of the challenges that are coming with it. But we've got to shift to another topic. So here we'll move into something that's a little bit more of a softball, and let's talk about ephemeral data.
Yeah,
So
such a softball.
yeah. So we're all, at least I think most of us are somewhat familiar with some of the problems with ephemeral data now. Applications like Signal or Slack's disappearing message function, where the data is there for transmission and then it has an expiration date and just vanishes, with varying different levels of evidence that it was there at all to begin with. So when you think about the problem of ephemeral data, what do you see aside from the obvious of do we know that the data existed and can we get our hands on it? What are some of the other both technical and legal problems that you've seen crop up around what seems to be a growing number of applications that have these types of functions built in?
Yeah. So I'm going to take a page from Daniel's book and I'm going to step back for a second and just define ephemeral data
Yeah.
for anyone who's listening. And that is essentially data that disappears on a given schedule. So if you're a Snapchat user, you know that after you send a snap, it's available for a certain amount of time. And it's really small, like a few minutes or 30 seconds, depends what your settings are. And then it's gone, right? And Snap has changed its mind year to year about whether they retain information on their servers or whether they don't. I think we're currently at don't. So that information is gone, right? Unless the user takes action to save it physically to their thing, or the recipient has the ability to change to their thing. So this The issues with ephemeral data kind of take us back to the issues with hyperlink. And the question is, what's the platform that's being used and how is it set up by the user? And so, again, you have to know and understand the technology. And to be effective as a litigator, you have to have a broad, at least broad understanding of the applications that do have ephemeral settings and whether they are ephemeral by nature or whether they have a disappearing message setting. So Snapchat is ephemeral by nature, right? You can't turn it off. It's as soon as someone watches it, the information disappears. Other platforms like Signal, Slack, Telegram, I had a couple others that I looked up before we got on, maybe Wicker. They have disappearing message settings, excuse me. So what you need to understand, and it almost needs to be part, not almost, it needs to be part of your custodian interview is when people are using those applications to transmit information, you need to understand what are their settings and are their settings going to keep that information when they're under a duty to preserve. But ephemeral messaging is just has to be layered together with the federal rules, just like everything else. And that is until you have a duty to preserve, you can continue to maintain your information in the way that you normally do as a business. And if that means disappearing message settings on Signal, then that's what it means. Should you have policies? I don't know if I would have a policy around ephemeral messaging. It's very fraught, right? How are you going to enforce it? How are you going to audit it? Those kinds of things. So ephemeral messaging is hard because the data disappears. Every application treats it differently as to what residual remains on the device or the computer that the message was sent from. There are tools out there that can capture some of that information, but if you need to capture that information, you need to understand what tools are available to be able to do that. And so it's a bit like the hyperlinks issue in that from a technical perspective, you need to understand what the challenges are, and then you need to have a plan for dealing with them as soon as possible when you get a new case. Ephemeral data is something that you almost need to talk about like out of the gate.
I love that there's a focus that you have there. I mean, you talked about that as well with the hyperlinked files, but here you're talking about for sure, this is the first thing you need to talk about. The question I have is, and I love your view on this, Kelly, is when we are talking about going ahead and saying, all right, do you utilize any sort of ephemeral data apps, et cetera, and having that right out of the gate, it really bifurcates two possible issues here. The first one is there a in the reasonable is there a reasonable use or in the ordinary course of business, I should say, ephemeral data apps are being utilized and therefore you can have a defensible approach. There's that one part. The other part is that the courts are looking at this and they're saying, well, if you're utilizing this, it's probably for a nefarious purpose. And I've seen the case law go in both divergent ways. What recent case law can you talk to us about that has been maybe most impactful when it comes to ephemeral data? And are there particular rulings or guidance that lawyers should really be mindful of as they are hearing you provide this guidance to them?
I knew you were going to ask me about specific cases, Daniel, just to put me on the spot. There are a few of them, and one of them we covered on the case of the week, and that was the FTC versus Amazon case. I'll give you the Westlaw site for that one in case anyone wants it. That's 2024 Westlaw 3342701. And in that particular case, the plaintiffs wanted ephemeral messages, and where they existed, they were required to produce them. And I think that is the first and most important question is where you used an ephemeral messaging application, does the information still exist? Is it relevant to the case? Can it be produced? Right. In Signal's a hard one, right? Because Signal was built end-to-end encryption. And my understanding is that Cellebrite just rolled something out that allows it to capture messages from Signal. We were having this discussion on a Women in eDiscovery panel yesterday, and someone from Concilio mentioned that Cellebrite has that capability. So that's an important one. Other tools that are just collecting mobile device data can't necessarily get to Signal data. And so you need to, again, have the technical tool that you need to get to the the issue. I don't want to get too far off the ephemeral question or the case law question. Most of the case law on ephemeral messaging really follows the rules. If the data still exists, then you have to provide it. If you can't provide it technologically, then you got to find a way to compromise with the other side about what's there. But when it comes to the loss of data that was ephemeral, the question then becomes, when did your duty to preserve attach? When was the data created? What were the settings on the device that housed the data? Should you have changed the settings because you were under a duty to preserve? That analysis is what happens. So the analysis for ephemeral data is really the analysis for everything else. And I liken it to hyperlinks because it's a technology issue, right? TikTok doesn't keep their data. Snapchat doesn't keep their data. So it's you have to know and understand these things if those are the platforms that are implicated in the type of cases you're handling, or you need to be working with someone who does.
Kelly, you mentioned that when you're getting involved in a case, understanding or identifying that there might be ephemeral data involved in the case is one of the first things that you recommend doing. At the same time, you said, from the corporate side, creating a policy around ephemeral data, difficult to enforce, fraught with a bunch of problems. So not necessarily the way that you should approach it. Are there other sort of proactive things that you would recommend either for outside counsel or in-house counsel when looking at the issue of ephemeral data, things that you can think about or do up front that might fall short of a policy, but still can help protect you down the road?
Yeah, one of the things that we do with our clients is a lot of organizations, corporations, I guess I should say, but a lot of organizations have what they call annual affirmations where clients sign, they agree, here's what the policies are related to data that's created as a result of my employment every year. And as a result of that process, we create videos to explain to them how these applications work and what kind of risk is associated with those from a legal perspective. There are, in most organizations, a couple of handfuls of people who are always the custodians who are on legal hold. And you can educate those people. So what you need to do for your organization depends on a number of factors within the organization. What kinds of litigation are you subject to? What are the actual applications that you're thinking about? What does legal really know, right? Because we know in the SaaS world that employees at organizations are setting up SaaS products all the time that IT has no idea what are happening, right? I mean, if IT is rolling out WhatsApp to the organization and monitoring it, if IT is doing that with Signal, which they're not, that makes a big difference, right? Because then you can go through IT, work with the bookshelves, but you can't if it's on an individual by individual basis. I've had cases where we had Signal chats between executives. We had WhatsApp messages between executives. We had text messages between executives because, and I think that the pandemic escalated this exponentially. We communicate in the method that most directly gets our message to the person the fastest when we need a response. If I don't need Daniel to respond to me for a couple days, I'm going to send him an email. If I need an answer right now, I'm going to text him. If my colleague is overseas, I'm going to send him a WhatsApp message or a Signal message. If I don't want anyone else to be able to see it, I'm going to send him a Signal message. What are you doing and what's the intent behind things? I think one of the challenges we have still in eDiscovery is when companies go out to hire lawyers, they do these very involved, really important RFP processes to find the right lawyers for the right piece of litigation, right? We used to just hire law firms and they did everything, right? We just called the right lawyer at the law firm to handle it. Now they do RFPs for just about everything. And I don't know if one of the components of those RFPs is making sure that they have the knowledge in eDiscovery to identify these issues immediately. So I almost think if someone calls me to put in an RFP, which we don't do very often, to be honest, but if they call me, I immediately send them a list of here's all the questions that you need to ask to make sure that you don't lose any data before you get involved in this process. And that's because we have so many cases where the data is just gone. To go back to Daniel's question earlier about WeChat, there was the Two Canoes case that we did on Case of the Week a while ago, which was a WeChat instance where the it was an issue about buying masks during the pandemic, and the owner of one of the companies was communicating with the Chinese supplier on WeChat, and the messages were gone. And it was a spoliation issue in the scope of the litigation. And so, and the owner never had any notion that he should be preserving that information. Couple that with the most recent decision that we had on Case of the Week, not yesterday's, but last week's, I think, in which the judge said that a verbal legal hold to a client is not sufficient. And when you say that, and then you start saying everything has to be in writing, you're creating this absolute cascading waterfall of stuff that has to happen at the outset of a litigation. And it's a lot. It's a lot to deal with. So ephemeral data is hard to deal with technically and legally, because if it's there, you have to preserve it and you got to figure out how. If it's not, you don't.
There's a lot of catch up here with the law and technology, and it reminds me of a conversation that we had on this podcast where we were talking about how the federal rules take between 4 and 6 years to change, and technology is going to be so far ahead, and
We
will
need it.
always
We
be
need a
far.
change. We need some updates, Daniel. We need some updates.
We do.
Not,
We
we
do,
do.
and I think that's an incredibly valid point. And when we think about the three things that we've covered on this podcast here, we've talked about the hyperlinked files, we've talked about Gen AI, and we've talked about ephemeral data. All three topics that literally can be a podcast episode, 1 hour podcast episode, all in and of itself. What I think that we've heard you say here, Kelly, is that really that from an organizational perspective, from a company standpoint, there really needs to be better communication internally.
Mhm.
And if I heard that right, whether it starts with legal operations professionals or whether it starts with, the general counsel's office and has this effect where we are talking to the the IT department, and we're talking to the chief privacy officer and the chief data officer, et cetera. And when we have the more communication and transparency around what is everybody doing and do we want to have a policy, and if we are going to have a policy, what is that going to look like? And I think if the organization can figure that out, then we can also reduce outside counsel spend on the amount of data that we're collecting or how we're collecting it, et cetera. So
That's
three,
exactly right.
I'm sorry, go ahead.
That's exactly right.
Yeah. So three very, very big topics here. I don't know if the topics can get any bigger, but i- if we forecast out the rest of this year and into 2026, I can't think of a better person that could potentially think of
Mhm.
what future trends might look like. So, Kelly, what else could possibly be on the horizon for us?
Well, I think as the reasoning capabilities of Gen AI grows, that we're going to start to see a lot more tools and a lot more technology around those. You're going to start having to understand the inner workings of those tools in the same way that sometimes we've had to have understanding of the way that the TAR process works. We started to incorporate Gen AI into document review, so you're going to have to start being able to explain how that is working and how you're using it, if that's required. I think there's an argument to be made that it's not required under Rule 34 right now. Um, I think some things need to be addressed about whether or not the rules need to be a bit more in line with technology. And this hyperlinks issue is a big part of it, right? There's nothing in the rules, and we don't get so specific in the rules as to say that hyperlinks are attachments. But the problem we have with the discovery case law is it's at the district court level or it's at the state court level, and it doesn't go up on appeal. Those are not appealable decisions. And when things do go up on appeal, they're few and far between, and it depends on the judge you get and the level of education that they have. So I think that Gen AI is going to continue to impact things because it's going to create new technologies that are then going to bring us more issues like hyperlinks, right? So the hyperlinks issue evolved because technology evolved in a way for us to better collaborate. And so as technology continues to evolve, which it's going to, and it constantly is, we need the rules to better adjust us to those existing technologies. We also need better education all the way across the board for all litigators, for law students, for judges. We need more for people to stay in touch with what's happening on these issues so they can have the level of education they need to make consistent decisions. Uh, The big issue that we have right now, and I was talking about this yesterday with women in eDiscovery, is the possession, custody, or control issue of, does an employer have control over an employee's personal phone? That issue is, that's where the policy issue comes in, Brandon, when you asked me about that. And I was like, I don't know if I want a policy. In two cases where companies had BYOD policies, the courts have found that the employer didn't have access over the mobile phone. There are more specifics to it than that. So please don't take that general statement as if you have a BYOD policy, you won't have control. In another case, a judge said, in the Miramontes case, the judge said, hey, this practical ability and legal right test for possession, custody, or control under Rule 34, it doesn't work with mobile phones. The way that we use mobile phones now, the way that we communicate for business, especially since the pandemic, means that analysis just doesn't fit modern society. And that's where I think the rules really need some updating. So I don't know if I got off track there. Sorry, guys. It's my soapbox.
No, not at all. And like we said, with every one of the topics that we've talked about today, we could spend an hour going off track, so to speak, down a bunch of different rabbit holes. So Kelly, we really appreciate the time you spent with us today. It's been a fascinating discussion. And it's one of those podcasts where I feel like we could have made this 3 hours and still not felt like we had fully plumbed the depths of just these 3 topics. But we really appreciate what you shared with us today, all the information you've given, and you've given us enough to really dig into some of these things on our own and learn a lot more about some of these challenges that we're all facing. So thank you again for the time, Daniel. I really appreciate it, as does our audience. And for those of you who are listening to this podcast, we thank you again for listening to the NeLI Pod, and we look forward to speaking with you again on our next podcast.
Thanks so much.
If you've enjoyed our discussion and want to learn more, don't forget to subscribe to our podcast on your favorite streaming platform. We're here to help you stay on top of the latest trends and developments in eDiscovery.
We'd love to hear your thoughts and questions about today's topic. Reach out to us via our social media channels or email us directly. Your feedback makes our program stronger and more attuned to the topics you care about in the world of legal technology.
Remember, all the resources and insights shared today are aimed at enhancing your practice and understanding of eDiscovery.
Join us next time on NeLI Pod as we continue to bring you expert knowledge and lively discussions. Until then, keep innovating, keep discovering, and keep pushing the boundaries of legal technology. Thank you for listening, and we'll see you next time.